Okay, good morning. I think we can sit down. We can start the second day of our autumn conference. So welcome both to the participants in the room and to those of you connected online. So yesterday we talked about fairness in the context of AI Act, in the context of the current debate on investment in the telecom infrastructures, and also in the context of the proposal of separate regulation. Today, we'll talk about fairness in the context of the Digital Market Act, which recently fully entered into force, and very recently the Commission designated the first gatekeepers. So in the first panel that I will moderate, we'll focus on the concept of fairness in the platform to end users relation, while the next panel, moderated by Professor Colangelo, the focus will be about fairness in inter-platform and intra-platform competition. And later in the afternoon, Giorgio Monti will chair the panel on fairness in the context of sector regulation of digital platforms in other regions of the world. So let me talk about fairness in general. Where do we start? I think we should start from competition law. Is fairness a new concept in competition law? And I think my answer is no. Why is not? First of all, because we find it in several provisions of the treaty, both in Article 101, paragraph 3, but also several abusive provision in Article 102 refer to fairness, let's say, but also in the case law of the Court of Justice about exclusionary abuses, we have a reference to fairness. And I'm not talking about very old case law about the 1970s, but I'm talking about a recent judgment. For instance, in the recent opinion of the Advocate General in Servizio Elettrico Nazionale, basically, he said that fair competition is synonymous of competition on the merits, competition on the basis of quality. So it's somehow a similar concept. And also, we have a reference to fairness in the recent ruling of the General Court in Google Shopping. So what I wanted to say is that fairness is not a new concept, but it has never been fully clarified by the Court of Justice. We don't really know what fairness means for the court, and especially we don't know what is the relationship between consumer welfare and fairness. So in these slides, I propose 4 different meanings of fairness, looking at different type of anti-competitive practice. So when we talk about Article 101, paragraph 3 and excessive pricing, we can consider fairness very similar to the concept of equity, so proper allocation of gains and burdens among different participants. But we can also see fairness very close to the meaning of correctness. So all the market participants should comply with certain type of behavior that are considered fair in the market. When we talk about discriminatory pricing, clearly the meaning of fairness is close to non-discrimination, equality, while when we talk about recent exclusionary abuses, and thinking about self-preferencing primarily, we talk about fairness in terms of equal opportunities for all the market participants. This is just a proposal, let's say, to how we can categorize fairness under competition law, and we can then talk about this distinction with the other panelists. In this table, I have listed some recent cases where we have already a decision, so not pending investigation, both by the Commission and by National Competition Authority, where to some extent we have some fairness consideration. As you see, most of the times, my feeling is that the interpretation of fairness in this case is closer to correctness, and most of the times the beneficiary, let's say, of this fairness are business rather than end users. The main exception is probably the German Facebook case, which is clearly focused on fairness between the platform and the final user. Let's now switch to the DMA. So we well know that the DMA has 2 objectives, fostering constant stability and fairness in digital markets. So we don't talk about contestability today, we talk about fairness. And if we read the preamble of the DMA, if we read paragraph 33, the definition of fairness, it's basically related to the imbalance between rights and obligation between the gatekeeper and business users. So there is no direct reference to end users in the definition of fairness in the DMA preamble. If we look at the obligation, including in Article 5 and Article 6, most of the obligation, it's well known in the DMA, aim at fostering cost and stability rather than fairness. We have, in my opinion, 5 obligations which have also a sort of fairness meaning. But again, I would say that in this obligation, the beneficiary are rather indirect, the end users are indirect beneficiary of this obligation. For instance, the obligation in Article 5.5, access and possibility for end users to access and subscribe to third-party apps. Clearly, the main beneficiary are the third-party apps, but indirectly, this allows the end users also to do certain things that could not be done before the DMA entered into force. Then if we look at the website of DG Comp, where fairness it's described, so this is more like a public view on fairness, and switch from a legal analysis to a sort of media analysis. There is this, I found this interesting paragraph mentioning that the consumer will benefit because of the DMA entering into force in terms of better services and also fairer price. So we have this reference to fairness in, let's say, the DG-Comp website, even though this reference to fairness and to the benefits for end users is not so evident, in my opinion, in the legal text of the DMA, is not so evident in the definition of fairness in the preamble of the DMA. So I stop here. I now leave the floor to the panelists. I would like to ask the panelists 4 questions. So first, fairness versus consumer welfare. Is it the same or it's something different? Second, and this is one general question for the conference, is fairness simply a political slogan, a temporary political slogan, or is something which will have long-term effects in how we enforce competition law and also, let's say, competition law in digital markets? And then what is the meaning of fairness under the DMA? Do we have the same meaning under the DMA and in competition law? And the last question is focus on the topic of this panel, which is, does the DMA effectively promote fairness in the relationship between platform and end users, even though there is no direct reference to this type of fairness in the definition of fairness in the preamble of the DMA, because the DMA mostly refers to business users. So I would like to discuss this question with our panelists. First of all, I'm very happy that we have today, unfortunately connected via Zoom because his flight was canceled. We have Thomas Kramler, head of unit at DG Comp. He has a very long experience in DG Comp, and he is now head of unit directly dealing with the enforcement of the DMA. Then we have with us Mario Siragusa. He's a very well-known practitioner, long experience in antitrust enforcement and Cleary and Gottlieb, and also visiting professor at the College of Europe. Konstantina Bania, she's partner at Geradin and Partners, but she's also a senior lecturer at Brunel University. And last but not least, we have Lucrezio Figurelli, who is principal at the Brattle office in Rome. So I would like to give the floor to the panelists. Let's say I will ask them to reply to one or more of the 4 questions mentioned before. But in the meantime, I would like to launch our poll question so that we can also engage the public connected via Zoom. So I would like to ask to the to those of you connected via Zoom to vote to the following question. Should fairness consideration have any role in antitrust and DMA enforcement in digital market? It's a very broad question, which I think it's interesting, not only for this panel, but also for the next panel. So you are free to vote, and in the meantime, we can open the first round of discussion. I would like to start with Thomas. Thomas, you have the floor.
Thank you. Good morning, everybody. And I'm very sorry not to be in Florence in person, but Lufthansa didn't permit. I really tried hard, but Lufthansa is not regulated yet as a gatekeeper by the Commission, so there was not much we could do about it. But let me jump into the questions right away. Fairness and consumer welfare, foes or friends. I think the answer is given by the judgments that you already mentioned. If you look at the very recent 2022 judgment in the Servizio Elettronico case, the court basically very bluntly says the ultimate objective of competition law intervention is the well-being of both intermediary and final consumers. And then in the next paragraph, or one paragraph up actually, the court says that covers practices that do not only harm consumers directly, but also harm them indirectly by undermining an effective structure of competition. So already have inbuilt in the case law the two concepts that we're all familiar with, exploitation and exclusion, and that debate, as you know, goes back to 1972, Continental Can, when the big question arose, what is actually Article 102 protecting? Is it protecting only against exploitative abuses? That was the debate at the time. People thought it's actually only protecting against exploitative abuses. And then over time, we moved more into the realm of exclusionary abuses. So for me, it's very clear that the concept of exploitation, and that's where the fairness concept comes in, as you rightly said, is very much enshrined in the treaty and in the case law of the courts, and is especially seated in Article 102A, which very clearly talks about unfair trading conditions and unfair prices, as you said. How does that play a role in digital cases, which is the topic of the debate here? I have two specific use cases, if I may say so, in mind, where exploitation and fairness actually plays a role, and where exclusionary theories of harm might find their limits. One use case is dual role platforms. So platforms which are, on the one hand, offering a platform service to third parties, business users, if you want, and on the other hand, providing the same service to end users at the same time. There's an inherent conflict in this setup, and if you want to be more practical about it, think about the marketplace that Amazon provides, and at the same time Amazon sells similar or the very same product at retail, or think about the app stores that Google and Apple provide, and at the same time they provide similar apps which compete against those apps which are provided by other app developers on their app stores. This has an inherent conflict of interest inbuilt in it, but these companies don't have the incentive to foreclose, because they're very much reliant on a big number of app store developers on their platform or merchants on their platform in order to build up the network effect, to build up the platform. They don't have an incentive to basically marginalize or even foreclose these players, the business users on the platform. But they might have an incentive to exploit them with a fee structure, with self-preferencing practices, to keep them from growing into competitors of the platform. And in these cases, it becomes important that we don't only look at exclusionary theories of harm, but can also deploy exploitative theories of harm. And the Commission is currently reviving, if you want, Article 102A in two cases. We're looking into that in the context of app stores, in the Spotify investigation, and then a statement of objections which is based on Article 102A has been issued, and in the context of the Meta case when it comes to data usage from the marketplace in terms of propelling the advertising service of Meta. So 102A is basically back just because of these dual role platform cases. So we see kind of a renaissance of the fairness notion in competition law. And the second use case, if I may say so, is data gathering. And there, I think the case at hand, which is the most interesting one, is the meta case of the Bundeskartellamt, or even more how the Bundesgerichtshof, so the German Supreme Court, framed it, and what the ECJ made out of it in its judgment of this year. The point in this case is that we're talking about kind of excessive data gathering towards users. So the theory of harm is that there would be an exploitation of end consumers because, in this case, Meta would gather more data than they should be gathering under the GDPR, and that's the benchmark, as the court has rightly said. This can be taken into account by competition authorities. And in these cases, this is obviously not about exclusion. This is about the fair treatment of consumers on your platform. If you want charging an excessive price in the form of data usage for using your platform, there an exclusionary theory of harm would make not a lot of sense because there's no exclusion of consumers. So if the end consumer is in the center of the debate or of the harm, then obviously one needs to debate the concept of fairness towards end users and cannot work with exclusionary theories of harm. So these two use cases, which are very live and practical, show already that the concept of fairness is not just a political slogan, it's actually a hands-on concept which is used in cases as we speak. The criticism is that all of this is not judiciable. What is actually fairness meaning? And you said so. I would disagree that the courts have never made a point about fairness. I think there is case law about fairness, a bit old, true, but fairness has been addressed by the European courts. But another point I wanted to make, the concept of fairness is not alien to the legal traditions of many member states. Just one example, there's the German law on unfair trading conditions, which predates, I think, by 50 years, the treaty. And it speaks about, in its Article 3.1, unfair commercial practices are illegal. And that has been justiciable over the last 100 years, and courts have rendered judgments on it, and it has been found to be a concept that courts can deal with. So I wouldn't submit or I wouldn't subscribe to the notion that the concept of fairness cannot be dealt with by courts. In practical terms, what the European courts have developed as a test is, I would think, a proportionality test. It's a test, if you look at the older case law where this has been developed, notably the BAT-Sabam case law, it speaks about the clauses that are subject to the fairness test need to be necessary to pursue the objective and need to be proportionate. So in essence, a proportionality test, which now in the newer meta judgment, I think has been linked to the concept of competition on the merits. So if a dominant company does something which is disproportionate to the objective it wants to pursue, then this is supposedly not competition on the merits and can therefore fall foul of the fairness test under 102A. It's not measurable, but that doesn't mean it's not justiciable, that courts cannot deal with it. And my example of the German unfair trading law, I think, with hundreds of judgments that have been rendered upon this clause, actually shows that the fairness concept can be applied by courts, and it's not arbitrary. Obviously, as we're talking about competition law, when the fairness concept is applied in competition law, it has to have an impact on parameters of competition. The conduct as such needs to have some link to the competitive situation. And I think that you can also distill from the meta judgment, especially and as well from the MIO judgment on discrimination, that there needs to be some link to parameters of competition. So choice, price, quality, or innovation need to be impacted, I think, by the unfair behavior of the dominant company in order to qualify a practice, not competition on the merits, and unfair in terms of the treaty language. Now, let me briefly talk about the DMA, as it is not competition law. Obviously, the DMA follows a different logic. We all know that the DMA has the contestability and fairness objectives inbuilt. As you already mentioned, the fairness concept in the DMA is enshrined or described in a recital. The fairness concept in the DMA is very much business user related. It's about imbalances between rights and obligations of business users and the gatekeepers. You find that in recital 33 of the DMA. What is important in the DMA context is that there's no analysis required of impact in terms of consumer choice, innovation, quality, as would be, in my view, under competition law. So the DMA basically, the legislator has already taken the position in the DMA about the necessity, the proportionality of the clauses. The DMA, as you know, is a very legislator-driven instrument because the prohibitions and obligations are formulated tightly, I would say. That means that there's not much leeway in terms of assessment, even of proportionality for the regulator, because the legislator has made a lot of these balancing assessments that need to be made in the fairness assessment already up front. So I would think that necessity and proportionality is mainly a legislator-driven decision in the DMA, whilst in an Article 102A case, obviously it is for the Commission to assess whether the conduct in case is fair or unfair. As you rightly said, the DMA focuses mainly on the business user side. This is driven by the concept of fairness, which is about the imbalance of the rights and obligations between gatekeepers and business users, and therefore only indirectly benefits, as you rightly said, the end users in terms of more choice in the end. So if more opportunities are created for business users, that should translate in more choice for the end users. And you already gave, I think, very good examples of where the DMA indirectly benefits business users. If you take, for instance, the obligation to ask for consent when you use or cross-use data across platforms, that's actually more modeled along the findings of the German Facebook case. Here you could even say that there's a direct benefit for end users in terms of more choice, because they can choose between a personalized or a less personalized alternative. When it comes to Article 6.3, for instance, choice screens, here also you have a direct benefit for end users. So choice screens will have to be shown in order for end users to be able to choose search engines and browsers. Where it is more, another direct implication is for end users is that they can now, under Article 6.9, take out the data from the platforms and use them for whatever purpose they want, their own data. They can also entitle a third party to do that, which is probably the more practical way of doing it. And as we have seen in open banking with the fintech industry, there's some prospect that might actually work properly also for gatekeepers. And then two provisions I would want to mention that where the effects are more indirect. It's first a side-loading provision in Article 6.4. As you know, the DMA asks gatekeepers to open up their platforms to alternative app stores. That should benefit consumers in terms of more choice indirectly. And then last but not least is the anti-steering provision in Article 5.4 of the DMA, which basically promotes the communication with end users by third-party developers and doesn't allow the app store providers to put limits in this communication and in the way third-party developers contract with the end users. So also that has an indirect benefit for consumers. So overall, whilst I agree that mostly the DMA only indirectly benefits consumers, there's some provisions, but there's direct consumer benefit to be drawn, mostly in terms of more choice that should be available. And I think I'll leave it at that for an introduction. Thank you very much.
Thanks a lot, Thomas. I would now like to give the floor to Professor Siragusa. So do you agree with his view fairness and consumer welfare are friends. What do you think?
Yes, thank you very much. Thank you for the invitation and to this very interesting panel. Now, I have a slightly different view than Thomas has explained. While, of course, I fully recognize that fairness plays a very important role in the application of the consumer code, and which, as you know, has a precise definition of what is considered to be unfair commercial practices, and which, for instance, in this country, is very substantially implemented and enforced. We have hundreds of cases in which our antitrust authority, which has the function of applying the consumer code, in which has applied those principles and prosecuted unfair commercial practices. So there is no doubt that in that field, the fairness plays a very important role, and it's a concept which is very precisely defined as to what can be considered and what are the elements necessary to consider a practice unfair. I doubt strongly that fairness has a role in competition law. As the discussion of yesterday clearly demonstrated, it's a very imprecise, it's very subjective, it's something which has to be applied depending on a number of different circumstances. I see very hard for this concept to have a role in the enforcement of competition law, which, as you know, has to be enforced also not only by specialized authorities, but also has direct applicability and has to be applied by all the national judges. So we need the concepts that are more clear, that are more definite, and we have in competition law a number of those concepts which have a long tradition of definition, which have a very rich jurisprudence, and honestly, we don't need the concept of fairness. First of all, it's true that Article 101 and 103 have some reference to fairness, but let's look at those references. First of all, Article 101.3 mentions the principle that we should allow consumer a fair share of the resulting benefit. But what is meant by that? There too, we have a clear case law which explains, and even the guidelines of the Commission explains, that the concept of fair share implies that the pass-on of benefits must at least compensate consumers for any actual or likely negative impact caused by the application of the exemption under 101.3. So again, a very economic concept. We have to see whether the benefits is such to compensate for the negative deriving from the restriction of competition, which is covered by the exemption. Also, if we look at Article 102, of course, Article Section A has a clear reference to directly or indirectly imposing unfair purchases or selling price or other unfair trading conditions. And this is clearly probably the provision which is more important for the category of exploitative abuse. Then we have 102C on discrimination, but there are two, since Article 102 makes a precise reference to the effect on competition at the secondary level. I think this is not necessarily an exploitative concept, it's more an exclusionary idea. Let's go back to 102A, so the exploitative type of abuse. Of course, as we know, in the application of Article 102, in general, preference has been given to the application of 102 to exclusionary abuses. There have been some cases of exploitation, which have recently become more frequent, right? Probably, and I think this has to do with this discussion on fairness. The main exploitative abuse has generally been considered the excessive prices. But again, what is the definition of excessive prices that we have from the General Motors case, the United Brands case, confirmed in the Akala judgment more recently, is of course that the price is, first of all, we have to analyze whether the price is excessive and whether it's unfair if compared to competing products. And this calculation is made on the basis of the costs of production and the value to consumers. Again, a very economic concept, which requires a very substantial analytical consideration of what are the costs and what are the benefits of the value which the consumers may give to this particular product. So again, a very economic concept, very far from the generic definition of fairness. There have been other types of exploitative abuse, but when you look at the case law, in most of what could be considered also exploitative abuse, there was an exclusionary effect. There are very few cases which are purely exploitative in the sense of not having an exclusionary effect. For instance, in the Sabam case, you remember the case of the Belgian Collecting Society, where the authors were obliged to grant to the society the management of all the portfolios of the rights, present and future, for 5 years after termination. Of course, such a provision had an effect on competition, because of course it excluded the possibility of the other collective society to manage the authors of that, the rights of that order. Again, also in Canal 5 and TV4, where the provision was the one regarding TV stations to pay to the collecting society a percentage of total turnover, this was held to be potentially abusive if there are alternative methods which are more based on the actual use. Again, of course, these also created more competition between the various collecting societies. There are some cases at the national level, probably national authorities use, but again, I think that this increased discussion, I will go into that later on fairness, is also a bit due to a populist approach which some of the national authorities have pursued in the recent years. Let me go very quickly through the provisions of the DMA, which both Marco and Thomas have analyzed. If you look at them, the few provisions which have been listed as having effects with respect to end user, they are all based on antitrust cases, all of them. Article 5.5 on anti-steering provision is based, of course, on the pending investigation of Apple and Spotify. Article 6.3 on the uninstallation of apps is based on the Android case. Of course, multi-homing, data portability are clear restrictions which have a very important impact on competition between the platforms. So it's clearly that they have, an important impact on competition. Maybe the only provision on which one could consider whether or not it was not a typical antitrust provision is Article 5.2, the provision now combining personal data without the consent of the end user, which of course, as you know, has been the subject of the Facebook case in Germany as an antitrust violation, but in Italy, as you know, has been pursued on the better of the consumer code in a much more efficient way than what the German authority has done. The Italian authority has succeeded in reaching the result that the German authority was pursuing in few months, and the provision has not been subject to appeal. And while, as you know, in the German case has gone through a very turbulent review by courts. So what is the role of fairness in competition law? I think it's very limited. It's too subjective, too imprecise. We have very clear notions. We have consumer welfare, which is efficient allocation of resources. This is the key objective of competition law. We have the notion of effect on competition. We have the notion of competition on the merits. Those are the notions that constantly are used in all the case law. Aggressive performance by powerful company should not be, which might be perceived superficially as unfair, it's not sufficient. And again, I repeat, this use of fairness, this constant talk of fairness has brought the attention of the competition authorities more to intent, but intent as such has no consequence under competition law. Intent is not sufficient to consider even an aggressive policy, even of the dominant company, to be sufficient to be a violation of Article 101.2. You need to prove that the actions which are pursued by the dominant company have the potential to restrict competition, and that indeed that are apt to restrict competition. That is the proper standard. Is it the competition on the merit? What the dominant company is trying to do has the potential of restricting competition? Yes or no? These are, I think, the principle that we should enforce, not the concept of fairness. We think that consumer welfare has to be defended as a notion. As you know, is subject to many different, a variety of different ideas as to what are the different interests that we should also protect within the notion of consumer welfare. I think that to introduce a fairness concept in the concept of consumer welfare is extremely dangerous, because of course the great importance of that definition has been that gives to the competition authorities at all levels the ability to resist political influence. And if we do not continue to consider consumer welfare as only an economic concept, but if we introduce other concepts, unfortunately, we will open the way to political lobbying and political influence over antitrust enforcement, which I think is going to be very dangerous and to be, you know, the end of our system. Maybe I can conclude here simply by saying that in order to protect the end user from unfair commercial practices by the platforms, we don't need the DMA. We have the consumer code. We have applied the consumer code in hundreds of cases against the platforms in a very efficient way. We don't need the DMA. The DMA has other effects, and I think that we should stick to the jurisprudence of the court, which has very clearly indicated that competition on the merit and effect on competition, ability to distort competition, are the concepts that national authorities, the Commission, and national judge should enforce in applying antitrust law. Thank you.
Thanks a lot. Very clear presentation. Let me remind those of you connected via Zoom that you can type your questions for the panelists during the first round of intervention, and afterwards we will read them, and in the second round of intervention, the panelists will reply to the questions, and you can also vote for the poll question if you have not done it yet. Konstantina, what do you think? Do you agree with Professor Siragusa, with Thomas? What is your view?
It's great that I come third, because I agree and disagree with both of them. And I would start with a statement that I thought would shock the economists in the room, but I think it might also shock Professor Siragusa after hearing his presentation. I will not discuss the treaties or the preamble of the treaties, from the EC Treaty to the Treaty on the Functioning of the EU. We have a reference to fair competition. I will not be discussing the case law. I will be making a more fundamental remark. The objective of the law, any kind of law, is fairness. Fairness is a fundamental component of the rule of law. In criminal law, we must ensure that the accused gets a fair trial. In consumer law, as Professor Siragusa mentioned, we need to ensure that traders are not subject, or consumers are not subject to unfair practices by traders. Competition law is no exception. So, discussing your first question, Margot, the difference between fairness and consumer welfare, I don't think there is a fundamental difference between the two concepts. If we accept that fairness is the objective of the law, and if we accept that consumer welfare is a legal standard on the basis of which we assess anti-competitive practices, then, of course, we need to address the issue of whether consumer welfare embeds the notion of fairness. And it clearly does. Let's take the example of consumer surplus, an aspect of consumer welfare, which represents the difference between the price the consumer is willing to pay and the price the consumer actually pays. Isn't what the consumer is willing to pay representative of what the consumer deems a fair price for the product? Isn't that a benchmark that determines consumer surplus and by extension the legality of competition rules? And since this panel focuses on platform to end users relations, allow me to make two remarks on the relevant decisional practice. The problem with the consumer welfare standard is not that it cannot encompass or that it shouldn't encompass fairness. The problem with the consumer welfare standard is that it has been equated for many years with consumer surplus, meaning the non-price dimensions of competition, such as variety, quality, and innovation that are very relevant to digital markets, have been cast aside. The second remark that I wanted to make is that it's not controversial to argue that EU competition law covers exploitative practices. Thomas has referred to many of them. So clearly it does. The treaty is there that refers to unfair selling prices, unfair purchase prices, and other unfair trading conditions. But Thomas also mentioned that these cases are very old. Well, yes, it was not an administrative priority. It's not because competition law should not pursue these cases. So I think that if we approach the question from this perspective, we realize that fairness and consumer welfare as normative concepts are more aligned than what we initially thought. And things are definitely changing. The cases that Marco referred to clearly had to do with fairness, especially the German Facebook case. But let me refer to one more example, the cases that concern data and privacy. So in Google DoubleClick, in Facebook WhatsApp, and in many other cases, the Commission said that data and data privacy have nothing to do with competition law. The day before yesterday, Commissioner Reinders gave a speech at the ICN making the following remarks. Consumers have evolved. They are concerned not just by how much they pay, but by other parameters too. Being fit for purpose means that our enforcement must be in tune with those realities. So we will assess whether the quality of data and privacy protections is a parameter of competition and whether the merger results in the loss of competition in this respect. Commissioner Reinders did not specifically refer to fairness in his speech, and I'm not going to get into the discussion how many times Reinders will refer to fairness compared to Vestager. He spoke about novel aspects of the consumer welfare standard. But doesn't it go without saying that both new and old aspects are about fairness? And this brings me to the second point, that distinction of fairness as used in the DMA and as the term used in competition law. I think that if we understand consumer welfare as a broad concept that encompasses low prices, quality, innovation, it brings me back to the quote that you used from the Commission's website, Marco. And it also brings me to some recitals in the DMA that specifically say that the DMA covers practices that lead to rapid and potentially far-reaching decreases in choice for both business users and end users, and that the practices the DMA covers are to the detriment of prices, quality, fair competition, choice, and innovation. So I think that the terms are more aligned than we think. However, I also think, and this brings me to your third question, the origin and meaning of fairness under the DMA, whether it's the same under EU competition law. And I think that looking at competition law only is wrong. Why? Because we need to take a look at other areas of law that have also influenced the text of the DMA. So Professor Siragusa mentioned the consumer protection regulation. That's one example. The second example is data protection regulation. Let me give you a couple of examples. Despite what the Commission was thinking when it was drafting its proposal, we have seen significant changes in the final text compared to the Commission's proposal. One of those provisions that was significantly changed is the anti-circumvention obligation. So based on additions to the Commission's proposal that made it to the final text, gatekeepers should not use behavioral techniques to undermine effective compliance with the DMA. Gatekeepers are also prevented from subverting end users' autonomy, decision-making, or free choice via the design or manner of operation of the user interface. So it's very clear that this anti-circumvention obligation covers what we call these days dark patterns that may influence an end user's decision. It's also clear that even though this is an umbrella provision that covers all of the obligations the gatekeepers must comply with, it's very relevant to the relations between platforms and end users. For example, how consent is extracted under Article 5.2 and how users are presented with choice screens under Article 6.3. It is very clear to me that this provision was not inspired by competition law, but by the Unfair Commercial Practices Directive. Let me give you one example. The Commission's guidance on the revised Unfair Commercial Practices Directive explicitly mentions that the directive covers dark patterns, and under the requirements of professional diligence in Article 5 of the directive, traders should take appropriate measures to ensure that the design of their interface does not distort the transactional decisions of consumers. And the guidance also notes that default interface settings have a significant impact on transactional decisions of average consumers. And of course, as such, they can breach the directive. The same applies to other provisions that cover the relations between platforms and end users. For example, Article 6.3, which essentially requires gatekeepers to make sure that users can switch from one service to another. Article 90 of the Unfair Commercial Practices Directive does the exact same thing. In fact, the Commission's guidance specifically say that these practices are covered by the directive, and in fact, that the directive also covers non-contractual barriers to switching. These are the commercial and behavioral techniques to which the anti-circumvention obligation of the DMA refers. So the same remark would, of course, apply to Article 5.2, fairness of data processing. This is very clear that Article 5.2 is inspired by data protection regulation, the GDPR, and not by competition law. So that's just stating the obvious. But I want to make a few remarks on the last question, whether the DMA effectively promotes fairness in platform to end users relations. And I'm not sure whether you wanted to emphasize the word fairness in this question or the word effectively. I'll go for the second. So overall, clearly, I'm a proponent of the DMA, and I'm optimistic about things will turn out. However, I do feel that with respect to the provisions that govern platform to end users relations, there are at least 3 issues that we need to consider. First of all, the theoretical foundations on which these obligations are based. So as you know, Article 5.2 and Article 6.3 and all the other provisions of the sort rely heavily on how the end user will behave. The end user must grant their consent. The end user must try to uninstall applications on the phone. And that reminds me of a quote I read when I was writing my PhD thesis on the media sector, which was discussing the concept of deregulation of media. And the author was very critical of this shift. And she was saying, the end user has been mutated from a set of powerless eyeballs in a fully enlightened and vigilant consumer. We make the same assumption with the DMA. So clearly, if we wanted to go for something that represents how consumers actually behave, and not with how we would want consumers to behave, self-determination, the principle of self-determination in the GDPR, we should arguably have gone for something more radical, just like the German Section 19A does, which prevents UPSCAMs from setting default settings, from pre-installing their applications, and all these sorts of things. So it takes a more radical position on the matter. However, with respect to these, let's just say, theoretical foundations, basis of the obligations, there are also big enforcement questions lurking in the background, because the question clearly goes beyond the privacy paradox and how users will behave. So for example, with respect to Article 5.2, it's not about users clicking agree. It's also about gatekeeper platforms using choice architecture to prevent users from making the right choice for them. This is, of course, set out in multiple market studies, more recently in the CMA market study on digital platforms, which explains how platforms nudge users into using their services, into agreeing to their privacy policies. So there is one fundamental question here, even if one argues that this will be caught by the anti-circumvention clause. Who is going to enforce Article 5.2? Who is going to assess whether consent is GDPR compliant? Is it going to be the Commission? Is it going to be the IDPC? Is it going to be both? But moving on from the theoretical foundations and relevant enforcement questions, I think there are 2 more issues to discuss. Interpretation challenges. And based on the work that I've already done on the DMA, clearly the DMA has no precedent and many provisions are subject to interpretation. But I find those that govern the relations between platforms and end users, those that raise the most interpretation challenges. So with respect to Article 5.2, I'm sure that everybody in the room saw that Facebook is proposing to introduce a fee for its services. And of course, that echoes to a large extent what the court said in the meta judgment and how perhaps Article 5.2 will be implemented. How is the Commission going to assess that the less personalized alternative is indeed equivalent to the personalized version that relies on data processing? Against what benchmarks will the Commission assess that the less personalized alternative is not of degraded quality? With respect to Article 6.3, which requires gatekeepers to present end users with choice screens, what does first use mean? Does it mean that it will cover legacy devices and new devices, or will be restricted to new devices only? Will it cover all access points from voice assistants to search widgets? So these are very important interpretation challenges that will arise from the interpretation of the DMA with respect to those provisions specifically. And one final remark, which we tend to forget, but I think it's going to be very important, the interplay with other regulations. I've already referred to the interplay with consumer protection regulation. One remark concerns one provision that Marco cited in his presentation, Article 6.9, data portability. How is that going to interact with the right in the GDPR. Clearly, the DMA goes much beyond, much further than the GDPR. It will cover both personal and non-personal data. Data portability can be done on a real-time continuous basis. How will consumers know which right to exercise, and how is this right going to be exercised in practice? So I leave it to that.
Thanks a lot, Konstantina. Yes, I fully agree. I think a common point with the presentation by Professor Siragusa on the fact that we are used to think about the DMA of a sort of sub-products of competition, but this is not exactly the case. There are also other sources in terms of unfair commercial practices, consumer law, which can also, to some extent, explain also this reference to fairness in the DMA. But all of us are lawyers, and now I would like to give the floor to our economist in the room, to Lucrezio. What do you think from an economic perspective?
Let's see. I hope to have half the energy of the previous panelists. This is a very interesting topic, and the more I think, come si accende?
Solo vicino.
Ah, okay. So, I'm glad to talk about this. It's a very interesting topic. The more I think about it, the more questions I have. Hopefully, I can try to answer the last question that you posed about whether the DMA effectively promotes fairness for end users. I did not focus on effectively, although I'll try to answer also in that regards. The short answer, I think, is yes, the DMA does focus on fairness to end users, and in various places, directly or indirectly, fairness for end users is mentioned. Marco pointed out to the web page of DG Comp, mentioning about the DMA bringing in more and better services, more opportunities to switch, fair prices for consumers. But looking into the DMA in itself, apart from the recital 33 that Marco mentioned, that was essentially defining fairness with respect to business users, there are other parts that are more explicit about end users. I can point to recitals 4 and 5 that are quite direct in looking at the features of gatekeepers that can lead to imbalances and lead to unfair practices and conditions for business users as well as end users. And that will result in the detriment of prices, quality, fair competition, choice, and innovation. Similarly, recital 5 looks at market processes are being incapable of ensuring fair economic outcomes. And I think outcomes is a key word in understanding in this context what fairness means. And so going to the broader questions about what is fairness. So clearly we're talking about a very fluid concept that as a fluid adapts to the shape of the context where it is being used. So I'm trying to answer in the context of the DMA and from economic perspective. I'm thinking about either an outcome or an environment that leads to an outcome. And in this sense, and thinking also about the 4 meanings that were put on the board before, equity, equality, correctness, and equal opportunities, in my view, we should think it about more of a quality, perceived quality, even price component, something more concrete. And going back to DG Comp's sentence, it's about more products, and more products mean higher consumer welfare. It's about better services. Better services means higher perceived quality by consumers. It means higher consumer welfare, lower costs of switching. That's clearly an improvement to allocative efficiency. Fairer prices, that must be understood as lower quality adjusted prices. So fairness to end users is not exactly consumer welfare. I think it's the fair operation of a digital market that leads to a fair outcome. Fair outcome in turn will result in higher consumer welfare. So clearly, we're not talking about something potentially measurable as consumer welfare, but we're talking about something concrete in the context of the DMA. So, but going back to the DMA, fairness to end users is mainly the result of regulating the relation between platforms and business users. And mainly, fairness is an indirect benefit for consumers that is achieved by ensuring fairness in the relation with business users. I'm saying mainly because when we talk about data, when we talk about choice of using another platform, another website, those are directly towards end users, but the main obligations for gatekeepers that result from the DMA and the main concerns that are expressed in the DMA relate to the relation with business users. And if we think about, requirements of interoperability, prohibition of self-preferencing, fair access to data, and I mentioned the ability to contract outside. Now, what do these obligations mean? Where do they lead? Now, clearly the objective is to reduce barriers to entry. It's to promote effective competition by other platforms and businesses, lowering switching costs. And now all of this is aimed at achieving fair outcomes for consumers. I was also thinking about why was the act focusing mostly on business users? In part, I kind of answered that, and it's that the main regulatory concern is in the relation with business users. Much of the issue in digital markets are huge network effects, extreme scale economies. And these facts lead to quite a nice condition for end users. Prices are zero, sometimes even negative. And the reality is that competition is hampered by the ability of gatekeepers to leverage a large end user base and self-preference foreclose. And that's why that is the regulatory concern that the DMA goes to address. I'm using the word regulation several times, more so than competition. And I'm going to tie back to what I heard earlier about the meaning of fairness in the DMA as opposed to other contexts, and fairness in the competition law. This is fairness concept that is also similar to regulation and regulatory frameworks, and I think fairness is similar to those contexts. And I'm going to close it here.
Thanks a lot, Lucrezio. So I think now it's the time to disclose the results of the poll. So I would say that the 84%, so a very strong majority, agree that fairness consideration have a role to play both in antitrust and the DMA enforcement in digital markets. Of course, the question was very broad, let's say, and probably also how the way in which it was formulated might have an impact on the answer. But I think the results of the voting is quite clear. Any question from the chat? No. From the room, please.
Hi, thank you very much. That was a really interesting panel. Completely makes it worthwhile skipping breakfast to come in on time. I had a question, maybe more for Thomas and Mario. We've seen and it's basically on the interplay between competition law and the DMA. And I guess what we're seeing, in the past sort of 5 to 7 years, the move away from the exclusion standard, the move away from the as efficient standard, for good reason, obviously, because there are considerations that can't be captured in those standards. I wonder whether a bit of that move is it's solved, whether that problem is solved by having the DMA. So I think of it as 2 different tools for 2 different problems. So if you expect competition to work in the market, then you might have kind of the classical competition law. And where you don't expect it to work, for example, in digital markets for platforms and other things, you might then want regulation. And I wonder if some of that move in 102 has actually been driven by the fact that we didn't have the tool and that we had to use competition law for a problem that we didn't have the tool to solve it. So we had a screwdriver, for example, and we wanted a hammer, and we used the screwdriver as a hammer. But now that we have a hammer, have we permanently ruined the screwdriver? Do we need to kind of get back to and make it a more sharp tool because now we don't need it to solve some of the other problems?
You're saying that what is the role of competition law after the DMA? Is that?
Okay. No, my question was more that the changes that have happened in the past few years, are they irreversible? Because now we have moved away from an exclusion standard. We have moved away from the as efficient standard. And again, for good reason, but I wonder that there's no way to get back to turn, the morphed hammer back into a screwdriver. Is it too late for that? Have we've moved them in the same direction where they're solving different problems? They should be orthogonal almost.
I can come in if I may. I think one of the issues we see in digital markets with the application of competition law is the measurability question, because it has become super difficult to put a price tag, for instance, on certain of these abuses, especially when we discuss data. When we discuss data, and data in these platform markets are basically the price that many of us are paying. You're very well familiar with the privacy paradox, so that people actually can't really measure or measure it differently when they're asked what the value of their data is. And I think we have put too much emphasis in the past in digital markets on measurability, and that has made antitrust enforcement extremely cumbersome and lengthy. And the DMA is, I think you're right, a reaction to that. I mean, there's a legislative choice to say, okay, let's, for certain specific conducts which we think are more likely to be harmful than not, do away with this measurability test and focus on their unfairness per se, because the legislator thinks, and that's a legislative choice, the legislator thinks that there are certain conducts for which you don't have to go through this measurability exercise, and you can find them problematic, unfair by object, if you want. So we're back to this kind of category because of administrability issues, because of the problem of measurability, because of the time it takes to do that, and therefore the limited impact that competition law enforcement has in these markets, given the time frame in which these markets move. So I think you're absolutely right that this is a deliberate legislative choice for specific conducts to move away from what has turned out to be sometimes illusionary, I might say, that we can measure every harm in terms of a price tag in competition law, because that seemed to have been the mantra for a long time, less in the EU than in the US, but partly also in the EU, that every harm has to be put a price tag on. Basically, I think that in data-driven markets for me is illusionary, and it's not going to lead to outcomes that work in a time frame which is a workable time frame.
Konstantina also wanted to give an answer.
Thank you. Just a quick question and a comment. You mentioned that, would it be impossible to go back to the as efficient competitor test and the economics-based approach? And why should we go back is my question. So I agree with Thomas 100%, because being difficult to measure does not, make it inappropriate to measure. So I will give you one example. In Microsoft Yahoo, the commission found that it had to focus on advertising markets and that the market for search results was not relevant for the case or for competition law for that matter. In Google Shopping, it adopted a completely different approach. Competition law should be about adapting the rules to the market conditions. If the market conditions say that price is not relevant, there are other parameters of competition that are relevant, we should be focusing on those. So it's still an economics-based approach. It's just based on different parameters. We just can't stick a price tag to these practices, as Thomas said.
We have two questions from Giorgio and Nicola. Maybe we can take them together so that then the speakers can reply to them. Giorgio.
Yeah, thanks. I wanted to latch on to Konstantina's point about effectiveness. So on the one hand, I mean, the discussion we've just had seems to say, okay, and some of you said it, some of the DMA obligations are antitrust cases transformed into the DMA. Now, if we agree that both are about fairness of some sort, we still have a problem with effectiveness, right? Privacy paradoxes, dark patterns. So how does the DMA help us deliver more fairness if it simply reproduces antitrust doctrine? And then is there anything more to the DMA that allows us to deliver effective fairness?
Thank you, Marco, and thanks to the speakers for a great panel. So it seems to me we are discussing whether fairness in the DMA is to be taken seriously as a concept with operative consequences here. And the laws are often made of terms and concepts which are completely empty. We know this. Every person that has practiced the law knows this. So this is the question, is this an empty concept or something that has consequences on reality? And maybe the DMA has the answer itself to that question. And so I'm going to phrase this as, two questions. So can an instrument that talks about end users in very general terms, without paying attention to class or individual differences in properties, be ever talking seriously about fairness? Should we distinguish between users located in poor neighborhoods or rich neighborhoods when we think about the application of the DMA? If you don't do that, you're not taking fairness seriously. That's the first question. The second question is, if it's not about this, if it's not about distributional fairness, which is the usual sense in which we talk about it, is this about reductions or decreases or deteriorations of quality parameters, non-price parameters? But is any reduction of quality unfair? Is this how we think about something that's unfair? A reduction of quality or an increase in quality adjusted prices? I think the answer is no. I mean, it seems to me the answer is no. So what is this concept of fairness except an empty motivation?
Good question. Wait, maybe we can have the second and final tour de table. Maybe we can reverse. And Lucrezio, do you want to answer?
Yes, I have some thoughts on these questions. I hope I provide some of the answer to the questions. I think it's important to think about what traditional competition law can do in the context of digital markets. And there are strong limitations with the typical tools used in competition law enforcement. I'm going to give one basic example: market definition. Defining the relevant market in digital market related issues can be an endless exercise. And there's been, I've participated in some of the big cases that have been going on in Italy. I mean, there are diametrically opposite views between parties and competition authorities. This is endless, and the DMA is an effective solution to this because it does not require a definition of the market. It defines core platform services pretty well, and it's a regulatory framework for solving a market failure that emerges when a gatekeeper is able to leverage its power due to a large customer end user base, due to network effects and so on. In terms of meaning of fairness, fairness between the treatment of one class of users versus another class of users and related issues, I think fairness here, and that's what I tried to convey earlier, is really about fairness in the relation with the platform and ensuring a fair operation of the market that is conducive of an outcome in terms of choice, quality, prices, that is fair. It's not about a quality reduction. It's about allowing firms to innovate with new services that will lead. But if you don't allow them to do that, then the system is unfair, the outcome is unfair.
Very clear. Konstantina, very briefly, because we're running out of.
To answer Giorgio's question, I agree with you, Giorgio. I think that the DMA will do something more than competition law. Clearly, all of the provisions to which we referred could be considered exploitative practices under Article 102. However, as I also mentioned, the DMA is clearly linked to consumer protection regulation and the GDPR. So, for example, with respect to the GDPR, the DMA makes a specific choice, consent. There are many other legal bases in the GDPR that could have been used, legitimate interest, performance of a contract. However, the DMA made a choice there and made it arguably more difficult for gatekeepers to comply with this provision instead of referring to Article 6 of the GDPR more generally. The same applies to consumer protection regulation. So all of these practices that we discussed today could be covered by the Unfair Commercial Practices Directive, as I mentioned. However, in the context of the Unfair Commercial Practices Directive, we would need an ex post assessment of these practices, meaning you would have to file a complaint, you would have to bring a case before national courts. In the DMA, these are prohibited ex ante. So I think, yes, the DMA will do something more from that respect.
Siragusa?
I agree a little bit with Giorgio. I don't see actually much added to the case law that has already been developed under EU law, under the Article 102, all which is pending. Of course, it's true that case takes a long time, but it's also true that once you have either an investigation to the Commission and for sure when you have a decision, I think that the platforms tend to comply. I think many of these obligations that are on the list are obligations which in general are already implemented by some of the platforms, at least the big ones. So the novelty of the DMA is, of course, an easier. We went from antitrust to regulation, so it's much easier enforcement on the side of the Commission. And it is also that it applies to companies which may not be in a dominant position. So that's probably the novelty a bit. So the smaller platforms which can be defined as gatekeepers that under the traditional application of 102 were not subject, of course, to 102. So that's for me the only really added value. Of course, what is happening, as you know, is that member states are strengthening their antitrust rules. So the Commission could have done the same. And as you remember, the original proposal of the new tool was a strengthening of the competition rules. But probably this was politically too difficult to achieve. So the regulation has been the alternative. I think not a very good alternative, but let's say an alternative. But member states, on the contrary, are reinforcing their antitrust law. So I see a conflict in the future, which I can imagine, and we see already of some of the cases pending in Germany, the national antitrust authorities want to pursue on the basis of antitrust So with all the provisions and all the right of defense and all the, you know, the necessity to prove an effect on competition, so we remain within the framework of an antitrust legislation, but they are enforcing. So I can see in the future the use of the DMA, I think, since the platforms have an interest in complying and in negotiating with the Commission, you know, the way in which they're going to implement the various provisions, certainly of Article 5 and then also those of Article 6, I can see the DMA is going to become a shield again for the platforms against the application of the national competition rules or actions, direct actions by private enforcement in national courts. As you know, the DMA rules may be direct applicable. There is a big discussion going on, but I think they are directly applicable. I can imagine that immediately there are going to be hundreds of cases which are going to be brought by, you know, various users of the platforms going to national judges asking for direct applicability of the provisions of the DMA, and to the extent that the platform has obtained, has filed its, you know, its report on how they are going to implement the provisions, these will become, as I said, a shield against the direct applicability, because of course the national judge will be confronted with the platform, which is going to say, look, I have this procedure to enforce the DMA, this procedure has been negotiated with the Commission, has been approved with the Commission, you know, who are you, poor national judge, which can do something differently? So that's the way I see, you know, the development. I never believed that, contrary to my learned colleagues, that antitrust rules were not sufficient to cope with the digital markets. Of course, they could have been strengthened, they could have been modernized, but antitrust has the ability, as you say, to adapt to the various circumstances in a much more flexible, a much more powerful way than a regulation has. But that was a different political choice. I want to also only respond to what Thomas said at the beginning, citing the cases of conflict of interest as not being exclusionary. Cases of conflict of interest are typically exclusionary cases, because of course, if you are if you have your own platform and on top of that you have services, you are exactly in the same position as we have seen historically in many antitrust cases. If you have the railway network and you also provide transport services, of course you have a tendency to favor or to obtain advantage for your integrated activities. There is nothing different, nothing new. We have a rich case law which has deemed that it's not an exclusion. It's true that the platform does not have an incentive to exclude totally, but has an incentive to gain an advantage vis-a-vis the other player. And it is a form of exclusionary, because you don't exclude 100%, but to exclude to a certain degree in order to obtain an advantage. So I don't see at all this difference. Thank you.
So last word to the Commission, Thomas.
Thank you. I think I'm going to come back to the question on fairness. Is it empty? Is it an empty slogan? Because that's what Nicola, I think, raised. In the law, it's actually enshrined very deeply as the yardstick for the interpretation of the law. There's Article 8.1 DMA, which says whenever a gatekeeper proposes compliance solutions, they have to be in line with the goals and achieve the goals of the regulation. So I guess whenever the Commission or a court will have to interpret the rules and the compliance measures that the gatekeeper has put forward, they will have to look into what is actually the aim of the regulation, and then have to come up with an interpretation in line with the fairness standard, which then brings me to what is actually the fairness standard under the DMA. I would think it's rather a process fairness standard. It should actually enable or create fair opportunities for the business users of the platforms, and it should create fair choices for the end users. So there should be a process in place that provides for both. Article 6.5 is a good example, the self-preferencing. It should basically be a presentation which is fair to the business users without the self-preferencing of the platform, and also gives end users fair choices about the different services that are available through the platform or presented through the platform. So I would coin it more in the notion of a process fairness instead of a distributional fairness, as Nicola has said. And I think it has a role to play practically in the interpretation of the law.
Thank you, Thomas. So I would like to conclude going back to my 4 questions and to see if we could agree on something or not. So the first question, fairness versus consumer welfare, are they friends or not in competition law? I think here the positions are very different. We heard the position from Thomas. Clearly, it's that we see fairness already in the case law of the Court of Justice, in the treaties. They are closer to being synonymous, while clearly Professor Siragusa warned vis-à-vis the uncertainty of this open concept, which has not been clarified by the Court of Justice, such as fairness. Is fairness a political slogan or something that will remain with us? I think nobody really gave an answer. Personally, I think it started as a political slogan, but it will stay with us in the sense that many of the cases are based nowadays on different fairness considerations, let's say. Why this is the case? Probably because I think was Lucrezio mentioned, simply the markets have changed. So now we are living in a digital world in zero price markets where quality and other aspects, let's say, are more important for the consumers. So we need probably new type of concepts, let's say, which go beyond consumer welfare. Question number 3, what are the origins? So Giorgio mentioned a very good point. Most of the obligations in the DMA are based on former antitrust cases, but also Konstantina mentioned this interesting point. So if you look at the anti-circumvention rules, you clearly have a reference to consumer law protection, to unfair commercial practices law, to data protection law, where you also have a concept of fairness. So this is also probably the origins and the reasons why we have fairness consideration in the DMA. Last question, which was also discussed by the panelists, does the DMA promote fairness in the platform to end users relations? I think yes, that was an agreement. I think it was a point raised by Lucrezio, but also by Konstantina in terms of order choice equality for the end users. But one open question remains what Nicola said, is decreasing the choice for users automatically to be considered unfair. This is, I think, open, and we did not really have an answer to the question posed by Nicola. So we are running out of time. I would like to conclude here. I would like to to thank the panelists. It was a great discussion.